welcome to today's program, Freedom of Expression in the Workplace, Navigating Title VII and the California Crown Act. I'm Ala Policastro, CLE Advisor for the Beverly Hills Bar Association, and I'm delighted to introduce this afternoon's speakers, Tracy Sanders Rucker and Kathiana Aurelien. Tracy Sanders Rucker is an accomplished attorney, author, and speaker. She established Natural Hair and the Law, an organization formed to provide publications addressing legal issues related to hair texture in the workplace and schools. Tracy is also the author of the Crown Act Handbook, Natural Hair Affirmations, and Natural Hair in the Workplace, What Are Your Rights? Tracy is the recipient of many prestigious awards for her work in community service, such as a Certificate of Special Recognition from our Los Angeles Mayor, Karen Bass. She's a frequent speaker at law schools and universities and contributor on various nationally syndicated news and talk shows. Tracy established the Attorney Tracy Sanders Foundation to help undeserved students achieve their education and career goals. Our second speaker, Kathiana Aurelien, is counsel in Wilkie Farr's Labor and Employment Group. She focuses her practice in California employment issues, and her practice includes counseling and representing her clients on a wide range of issues, including employment implications of corporate transactions, workplace investigations, evaluations of worker classification, and implementation of reduction in force, as well as defense against discrimination and retaliation claims. Kathiana is a frequent writer and speaker on employment-related topics ranging from cannabis in the workplace to the impact of the Dodd-Frank on employers. She currently serves as on the board of the Black Women Lawyers Association of Los Angeles and is the co-chair of the Pro Bono and Community Outreach Committee for the Labor and Employment section of the American Bar Association. We're so excited to have them here with us today and can't wait to hear what they have to share with us.
Thank you so much. So first and foremost, we'd like to thank the Beverly Hills Bar Association for your courage to present Freedom of Expression in the Workplace, Navigating Title VII and the California Crown Act. I do believe we have a moderator who will help us navigate the slides. So if we could move to the next slide, please. What we'd like to do in this CLE is to help you understand the Crown Act, and we don't want to take anything for granted in terms of having acronyms, because some of you may be familiar with the Crown Act and others, this may be a niche topic. So we are not insulting your intelligence by taking a very elementary approach to this topic. The Crown Act stands for creating a respectful and open world for natural hair. And the Crown Act has been enacted to prohibit hair texture discrimination in the workplace and schools. And don't worry, if you never have to wake up a day in your life thinking an inkling about hair texture or discrimination, it sounds like an oxymoron. My esteemed co-speaker and I will take you through those issues and break down some definitions for you. So the Crown Act has been enacted in 27 states. So even if you are not familiar with Black culture, Black hair, if you think no one's filing these cases, you know, wait a minute, it could impact you anyway, especially as an employer, or if you're in-house providing counsel to employers. And you could, in fact, find yourself needing guidance as a plaintiff. The Crown Act has been enacted in 27 states and 40 localities. In the interest of time, I won't go over all 27 states, but do know that on the West Coast, California, and Nevada, and on the East Coast, New York, and Connecticut, New Jersey, for example. The Crown Act has also been enacted in U.S. territories such as Puerto Rico and U.S. Virgin Islands. So many of you may be conducting international business, especially during our current political climate, which we will not discuss. But if you are in global trade or international affairs, the Crown Act may be implicated. So this is especially important for employment lawyers who advise on employment law as well as human resources matters. And it could also be helpful to educational institutions. If we were together in person, I'd ask, how many of you have seen the cases in the media where kids were expelled or suspended from school because of hair texture? Those cases might involve the Crown Act as well. So we will move on to the next slide, please. So the Crown Act, as I mentioned, had been passed in 27 states, but in the interest of time, you will receive this PowerPoint and some relevant cases that Ms. Aurelien and I have pulled, so you will be well aware of the issues. But to know that because this is the Beverly Hills Bar Association and we're in the state of California, we're going to focus on the California Crown Act. And moving along to the next slide. Let's go over what the Crown Act means. So it stands for creating a respectful and open world for a natural hair. In some states, you might see it as an open workplace. Those terms are interchangeable. If you see the Crown Act, just think of two words, hair texture and discrimination. So usually California, the most progressive state in the nation, is always the first of everything. California, in fact, was the first state to enact the Crown Act. It became effective during COVID, January 1 on 2020. So this CLE seminar is not pro-plaintiff, it's not pro-management. Currently, as an entrepreneur providing legal education, I have experience on both sides. Ms. Aurelien is management, but we are taking an objective approach today. And I'm going to take you through some nuances related to the employees' rights, and Ms. Aurelien will go over some employer rights and compliance issues. Also, as we go to the next slide, please be aware that even though we are in an anti-DEI climate, and it doesn't matter if you're in a red state or a blue state. Right now, I'm at a lake in South Carolina, as red as it can be. Live in California part of the year, blue state. It doesn't matter. We should still be aware of the Crown Act and employment laws because we are still one nation. And as practicing attorneys, we want our clients to be well aware of labor and employment law. So I have a quick poll for you all. If you see this slide, and Kathiana will come on soon to take you through some samples of hairstyles, one of which she's modeling. But before we do, let's go through the difference between employment and labor law. Again, I believe in being very, very simple because you gain more by going broad and coming narrow. So if we were together and I asked, do you think discrimination based on hair, is that employment law centric or labor law? And you all can type in the chat if you will. Discrimination based on hair, labor law or employment law? And the lawyerly answer would be both. But if you're focusing on primarily filing a claim in court, are you going to pull labor law or employment law? What about wrongful termination after reporting discrimination? Labor law or employment law? Union organizing, employment law, labor law, collective bargaining, labor law or employment law? What about wage theft and unpaid overtime? Labor law or employment law? And finally, retaliation for union activity, labor law or employment law? And the reason why Kathiana and I thought it might be good to just do a refresher is because you'd be surprised, especially if you're not practicing labor and employment law. A lot of times the two can be intermeshed. But as I turn it over to Kathiana and we go to the next slide, you'll see that a lot of the issues can be intermingled. But before Kathiana takes you through the different samples in terms of hairstyles, so you understand what we're talking about, know that Crown Act legislation, and there are a few cases in California which we will discuss, primarily employment law, because employment law is the relationship between the employer and an employee. There could be labor law implications if you are representing unions or if you have organized labor and if you have Black plaintiffs or plaintiffs with textured hair who are complaining about being discriminated. So if you are practicing labor law, please don't think that this is an exempt practice area. There could be labor law implications. Now, freedom of expression, and I promise you'll hear from the next generation because we're taking an intergenerational approach. Freedom of expression in the workplace, generally you think of, remember constitutional law and the F word in the draft, which I won't say because I'm not a potty mouth. Usually people think about freedom of expression in the First Amendment. They think about the flag or t-shirts of vulgar language. Well, freedom of expression and the First Amendment does have intersectionality with the Crown Act because it's no different than freedom to behave in a certain way in terms of words that may be used. It's just how we present ourselves in terms of hair. So just know that there could be First Amendment implications based on freedom of expression if a government agency is implicated. So if you work for the government or work in a school and it's a public school, or if it's a religious reason. So Kathiana is wearing a hairstyle. I'll let her tell you about her hairstyle and how a person might find that the Crown Act is implicated through their hair, First Amendment, if it's religion, right? So there could be a Crown Act claim and First Amendment. And she's going to take you through some hairstyles as we go to the next slide. I wrote a book called The Crown Act Handbook. And instead of me shamelessly promoting my book, Kathiana is going to take you through some of the graphics. For those of you who might not know the difference between natural hair and natural hairstyles, and then she's going to explain the different hairstyles.
Thanks, Tracy. Next slide, please. Oh, I think we might have skipped the slide. I'm sorry. Can we go back one? There we go. So what is natural hair and what do people mean? You know, when they talk about natural hair, what does that mean? And bottom line, different people have different ideas around, you know, what natural hair constitutes. When people talk about natural hair, they might mean, you know, hair that hasn't been chemically altered, right? It might mean hair that's not chemically relaxed to be straight. I've seen workplace policies around restrictions for employee hair as far as hair color. So employers have had policies where they don't restrict an employee from dyeing their hair, but they do say that if you're going to dye your hair, if you're going to have hair color, it has to be something that's naturally occurring in the world for humans, right? So when you think about that kind of policy, what they're trying to get at is, fine, dye your hair, we don't care, but don't come to work and think you're being compliant with our policy if your hair is pink or purple or, you know, some other color that's not thought of as naturally occurring. For some people, natural hair means hair that's not dyed at all, right? In certain communities, and Tracy kind of touched on this a bit in her earlier slide, references to natural hair means wearing your hair as it naturally grows from your scalp, your natural hair texture, whether that means naturally wavy, naturally curly, tightly coiled, some hair textures described as kinky hair. It could also include what's described as protective styles. And that's a term that we see in several of the various different Crown Act statutes that have been passed in different states and municipalities, right? They don't necessarily define the term protective styles. What they tend to do is give examples where they include things like locks or braids, which Tracy mentioned, my hair is braided, right? And so within the statutes of different Crown Acts, including California, you know, braids is described as an example of a protective hairstyle, and in many communities described as a natural style. Protective styles are essentially styles where hair is tucked away or protected, and usually referring to the ends of the hair from the elements, whether that's from the elements or heat or frequent manipulation. Right, so that's what we think of when we think of protective styles. It could also be a wig. It doesn't have to be braids or locks or bantu knots. And when we go through some of the illustrations that Tracy flagged, you'll get to see a few of those styles. And in excuse me, in passing the California Crown Act, the state legislature was sort of getting at sort of hair texture discrimination And in some of the legislative history, they find that there are ways in which employers and just societal norms have been sort of seeped into sort of Eurocentric ideas of what constitutes professionalism, and relatedly have associated traits that are associated with Blackness or Black communities as unprofessional. And so in trying to tackle that and give certain protections, that's where the Crown Act kind of comes in to fill in the gaps of certain anti-discrimination laws that you currently have already on the books. Next slide, please. So very first slide, very first illustration here, I think of as a pretty recognizable hairstyle, but I do appreciate that maybe not everyone knows, but this is an afro, right? Popular probably a few decades ago, but still very prevalent today. And because of the way that courts have tackled defining race and interpreting anti-discrimination statutes currently on the books in the federal statutes, I mean, afros are a protected hairstyle. They're a protected category under Title VII, and of course, as well as the various different Crown Act statutes. And interestingly, in one of the earlier sort of cases after the passage of Title VII, but it's a couple decades later, this was in 1981, a employee of an airline brought a claim alleging discrimination and saying that her employer's policy violated Title VII because she wore her hair in braids, but cornrow braids. So they are different than the ones I have on, right, that I'm wearing my hair now. But she had her hair styled in cornrows, and she was an employee of this airline. And they said, hey, you would have to change your hairstyle in order to comply with our work culture. We don't allow for cornrows. And she, went to court, and the Southern District of New York ruled in favor of the employer and against the employee, and essentially said, well, look, Title VII does provide some protection, but not for what they considered more styles that could be changed. And I want to get the language right, but they took the position that braided hairstyles were not a product of natural hair growth and an easily changed characteristic, even if it is socioculturally associated with a particular race or nationality. Braids were not protected under Title VII, and they weren't going to expand it that far. But they did go on to say, had you had an afro, now that might have been different, because that is something that we connect with race and not braids. And so that was an interesting early case, and later we'll talk about another more recent case and how that's played out as well. And spoiler alert, hasn't changed much under Title VII. Next slide. So here we have yet another very familiar style here. This is what we would call braids or twists. And while this style would not be, at least under current case law, protected under Title VII, it would be under most of the various Crown Act statutes that have been recently passed. Same for the next slide here. These are locks, and there are a couple cases that we'll talk about later where folks have brought claims because their hair is locked and it's either running up against their employer's policies or deemed unprofessional for some reason or another. Next slide. Last here is what are referred to as Bantu knots. And it's another protective style, which, as I talked about earlier, tucks away the hair, not much manipulation there. It's kind of going to sit like that for a while. And that's a protective style, which would be covered under the Crown Act, but not under current case law, Title VII. Next slide. So I've mentioned now Title VII a few times, and it's a federal statute that prohibits employment discrimination. There are protected categories under the statute, and I'm sure some of you are very familiar with Title VII. For those who are not, protected categories under this statute include race, color, national origin, religion, and sex, right? So generally it applies to employers who have 15 or more employees. And when it comes, as I was mentioning earlier, to hair texture and hairstyle protections, there isn't a lot of, we're going to expand this. It's really limited to afros per the case law. Now, a more recent case than the 1980s case I mentioned earlier is this EEOC v. Catastrophe Management Solutions case, where in 2016, the 11th Circuit affirmed a lower court ruling finding that the employer had not violated Title VII after rescinding an offer that it had given to an employee who, or to an applicant, rather, because that person had not started, because they refused to cut their locks. She took the position that, she could wear her hair up, and so she could comply with their policy, but the employer took the position that that was going to violate the policy, and went up to the 11th Circuit, and they had similar reasoning to the earlier Southern District of New York case from a few decades before. And the court basically said that the protections aren't extended to hairstyles culturally associated with any specific race, and instead to sort of what they draw the distinction between mutable and immutable characteristics. And for the rationale is, afros are sort of an immutable characteristic, whereas locks, because they can be changed, if you know anything about locks, they take a really long time to form and grow, but that falls in the immutable category. Next slide. Oh, so Tracy's going to take us through some of the EEOC guidance.
Thank you, Kathiana. That was a great overview of natural hair and protective styles. So Kathiana is modeling a natural hairstyle, and I'm also modeling another form of a natural hairstyle, as she mentioned. A person might, and this is kind of a sensitive topic because most HR professionals and lawyers will agree, you're not going to go up to an employee and, if there's a file claim saying, hey, we inspected or policed your hair and it's natural versus natural hairstyle. But the reason why this is also important is because there could be an underlying medical condition where the ADA might be implicated, right? So if someone if it's a male and he has PFB, which are razor bumps, and that's like a huge issue right now in the US military, Marines in particular, there could be an underlying medical condition. And then sometimes for women, if you're contending with alopecia or hair loss in the workplace, which is why I initially wrote the book back in 2016. And it's not as if this is a hobby and I have nothing else to write about, but it's deeply personal to me because about 10 years ago, I started going through the process of hair loss and having to work at that time at a larger law firm and didn't know what to do. So I had to wear what is called artifice. So when Kathiana mentioned the law, and if it's your own hair or artificial hair, a person's natural hair growing out of their follicles would be protected by Title VII. But unfortunately, if it's someone who faced my situation and you're dealing with hair loss and you're having to cover up hair loss in a protective style, then so sad, too bad. That was before the Crown Act. So the Crown Act, where it has been adopted, is now filling the gap. And for employment counsel, know when you're screening, you should also screen for underlying conditions, even if your management side, you don't want to be surprised, because if it is in fact an underlying medical condition why this person is wearing a certain hairstyle, not hair colors, we're talking about protective hairstyles, even if you're not in a Crown Act state, that could be another exception in terms of violation of possible dress and grooming codes. So what are dress and grooming codes? even if you don't know about the Crown Act until today, you think you might not ever see a Crown Act case, because we are in a current anti-DEI climate, it is highly advisable, and Kathiana is going to take you through this as well in terms of best practices, to check your employee handbooks and advise your clients to make sure those employee handbooks have been updated in terms of grooming standards. Grooming standards have been suggested by the EEOC, such as this slide. Generally, you want grooming standards that are gender neutral and race neutral. So in this particular slide, there is an example of one person being able to wear sideburns and long hair, and that employee was white, whereas a Black employee was not able to wear an afro and sideburns. Next slide, please. And you all probably know that EEOC is an acronym for the Equal Employment Opportunity Commission. So we provided for you cases where the EEOC actually initiated claims on behalf of plaintiffs who believe that they were not treated fairly based on grooming standards. So when you're advising clients, always go to .gov. When I do CLEs, I always say go to .gov, because whether we like it or not, we're still the United States. And all of our main legislation is going to come first federal. So if you go to EEOC.gov, look for grooming standards, find out what EEOC is stating. That's your first place in terms of compliance and legal risk management. And believe it or not, the EEOC has been writing about this for decades. It's just now becoming a little more in vogue or mainstream after the Crown Act, but there's a lot of cases, as Kathiana mentioned, going back to hopefully before both of us were born. So I'm trying to claim some youth here. Next slide, please. And if you have any questions about how best to enact your individual employee handbook, take a survey of your employees. They can voluntarily provide self-identification information, male, female, race, gender, because you don't want to spend a whole lot of time on this if it's not relevant to your workplace. But a great place to start is possibly doing a survey, and then make sure that your employee handbook is up to date based on the Crown Act and other relevant laws. Plaintiff side, you want to make sure that you read the employee handbook. You can't march over to the EEOC and file a claim, if you've not read the handbook, and if you've not provided the employer with notice that you feel that you've been discriminated against. That's the first step of filing a claim. So if you feel you've been discriminated against, read the employee handbook. Let the employer know what your complaint might be, and then you would want to start documenting and gathering evidence. And Kathiana is going to take us through a case today. In-N-Out Burger, don't throw tomatoes. I like In-N-Out, but she's going to kind of mention that case. We don't know what's going to happen. It's pending legislation, but we do think that employers and employees should be aware that this is big business, and your potential business could be impacted. Even if the case is dismissed, you just don't want that kind of PR in the media. So let's go on to the next slide. I'm going to basically go over the Senate bill, and then Kathiana is going to go over the next slides. But if you would like to actually read the Crown Act, it has been amended to include not only workplace and schools, but now it includes also public spaces and public accommodations, but we're focusing on the workplace. But just know it's very broad, but today we're only focusing on the workplace. The original version was Senate Bill 188. And again, California was the first state. So a lot of states have modeled their Crown Act legislation after California, but please be aware, if you are representing big practice, you have multi-state litigation. Some states only have Crown Act covering the workplace. Others, like Virginia or Arkansas, it's only the schools. And then others are all inclusive, like California, of everything. So just be aware that the statutory codes differ by states. And plaintiff side, Also be aware, because if someone reaches out to you about a workplace issue and you're going to file in a state where it's only schools, then it's not going too far. So just know that each state has its own set of statutory codes. And I will turn over the next slide to Kathiana, sorry.
All right, Tracy, thank you. So Tracy kind of covered the intro on the California Crown Act, creating a respectful and open workplace for natural hair. You'll see that very different, slightly depending on the state. Sometimes it's creating a respectful and open world, which is, you know, an ambitious sort of objective here for natural hair. California is creating a respectful and open workplace for natural hair. As she mentioned, it was the first in the nation to have this kind of statute back. It was signed in 2019, became effective the following January. And what the law does is that it expands the protections to that are provided under FEHA, the Fair Employment and Housing Act, and amends the definition of race to include traits, initially traits historically associated with race, like hair texture and protective hairstyles. The amendment takes away the word historically because it added a little bit of ambiguity there. So now it just, you know, says that it includes traits associated with race, like hair texture and protective hairstyles. The statute, so I know I mentioned earlier Title VII, which applies to generally to employers with 15 or more employees. FEHA has a lower threshold where it's 5 or more employees that provide protections against discrimination and retaliation. The statute also, as far as the harassment protections are concerned, apply to all employers, whether you just have one employee. So for management side counsel here that are taking this webinar, you know, it's important to note the different thresholds and whether or not the statutes in different states apply to your particular client. The FEHA, like the federal statute, you know, does have certain very narrow exceptions that might apply as a defense in certain situations. The California Civil Rights Department has some enforcement authority in California. It's previously called the Department of Fair Employment and Housing, DFEH. Now it's the Civil Rights Department. Next slide, please. As I mentioned, Assembly Bill 1815, which was the more recent amendment to the, which, you know, just last year passed, amending the original statute, removes the word historically, and also, as Tracy kind of referenced earlier, builds on those protections by amending the Honorary Civil Rights Act. So it goes outside of the just workplace protections previously provided. Next slide. So, okay, some of the more recent, and again, this is a recent statute, so I think case law is going to continue to develop. Statutes, or rather, claims are going to start, probably, you know, being filed more in the various states, including California. But in December of 2019, the DFEH, because it had not yet gone through its rebrand to the CRD, issued a press release regarding a settlement that they had with the CEO of the Business Resource Group, where a former employee filed a complaint with the DFEH alleging that the company CEO was going around calling her unprofessional whenever she wore her hair either curly or in braids. And he would go the extra step of saying, "Oh, well, that looks good," or "that looks professional." And these are, you know, the claims that she alleged in her complaint. But he would say, "Oh, that looks better when she wore her hair straight," right? And this is just a press release, so we don't have a lot of the facts here. But the agency did note that the CEO had agreed to compensate the former employee some undisclosed sum and had agreed to a minimum of 2 hours of harassment prevention training. So that's one example that happened at the end of 2019. Next slide. The Thornton v. Encore group is an interesting one. This is back in 2021. And all we have here is a complaint that was filed in state court in San Diego County in November of 2021 here. The applicant, who was a black job applicant, interestingly, had worked for this company prior to COVID. So had worked for 4 years in Florida for this company, had not decided to lock his hair yet at the time. And so he worked for 4 years, then was furloughed because of COVID. So during the furlough, he opted to move to San Diego. And while in San Diego, received notice saying, hey, reach out to the company about restarting work. And so he did, and interviewed for the same role that he previously held. Technical supervisor was the title. And I think they even, at least in the allegations in the complaint, went so far as to tell him that he was qualified. He'd done the job before, he was suitable for the role, but he would need to cut his hair. And that now that he had locked his hair, he couldn't work there unless he cut his hair. And again, we just have the complaint. The company did issue a statement saying that it was just a misunderstanding and that they had an offer open for him if he wanted to come back. We don't have much more in terms of facts there, but that is something that, given these new protections and sort of filling up the gaps in terms of hair texture and different hairstyles, it's important as employers to take a look at these policies and avoid sort of situations like this where they are avoidable. The last sort of recent case, and this one is a very recent, is the In and Out case that was recently filed here in California, where we just again have a complaint. There's not much to report. This person, though, the issue seems to be that the sideburns are the primary concern, where he's alleged that his supervisor sort of kept nagging him and taking, being super critical of things that other employees were not given, a second thought about, and being requested to go be clean shaven. He didn't have any other facial hair other than sideburns, and they thought that that was too long and asked him to go home during one of his shifts and to come back after he had shaved. And he decided, well, I'll come back for my next shift. I'm not changing my sideburns, and was fired. That's the allegations in the complaint. We don't have more information there, but again, it's a developing area of law because there aren't a ton of challenges around, well, what all is inclusive of protective hairstyles, what's really going to be related to race in terms of traits, right? So it's definitely an interesting and an exciting area right now, and deeply personal to many.
Yeah. And Outburger is like a California staple, so.
Yeah, I hear they're the CEO, I think, is moving. At least that was in the news recently.
Oh wow.
Yeah, but in terms of best practices for employers, now that these laws are being enacted, that some employers have employees in various jurisdictions, not just California, right? Or maybe you're currently advising an employer who just has pending legislation, or it's always important to kind of check updates to these different laws. In California, statute was only recently updated, but you want to check the handbook. I know I mentioned grooming policies earlier with respect to hair color, but if there's a policy and you're in California that prohibits braided styles or prohibits locks, maybe there's a BFOQ, a bona fide qualification reason for that, and maybe you can have that defense, but those are narrow, and short of that, you would have to update the handbook or the policy to be compliant with the new state law, right? So it's important to train employees and particularly HR managers and supervisors around risks related to hair texture discrimination and how that ties back to race discrimination and race protections under the various statutes, related litigation risks too. So as we know, even a nuisance complaint or a weak complaint can still disrupt the workplace, can still be a drain on employee morale, can still be something that costs the company a lot of money. So implementing proactive internal complaint procedures is also key in managing workplace functionality, making sure that the workplace is something that is smooth for as many people as possible. Auditing workplace policies is something to do. And again, this is sort of reviewing your policies, making sure you're compliant under federal and state laws. Some states don't have necessarily a Crown Act, but cities do. So there are different local statutes that have adopted, different localities that have adopted their own sort of smaller Crown Act. So it's important to, even if a state doesn't have it, check to see if a city does. And again, understanding how different hairstyles might be protected under different statutes and fostering sort of a workplace where employees don't necessarily harbor bad will towards the employer is always a plus, right? So if people feel like they're seen and heard, they're more likely to be happy and then less likely to bring claims against their employers. Tracy?
Sure, thank you,
Kathiana.
Kathiana.
Employees' considerations.
Yes, you did a great job. Thank you. We do have about 15 minutes just to give you all a time cue. At the end, our moderator is going to take questions. So if you have any questions, please put those in the chat and we both will answer. As we wrap up with best practices for employees, because we have a few more minutes than I thought, we're both respectful of your time. So we wanted to be careful to not elongate anything. But quickly, some of you may be in different states, if you're employees or if you're possibly filing a claim yourself, unfortunately. Just know that Alaska, Arkansas, California, Colorado, Connecticut, Delaware, Illinois, Louisiana, Maine, Maryland, Massachusetts, Minnesota, Nebraska, Nevada, New Jersey, New Mexico, New York, Oregon, Tennessee, Texas, Virginia, Puerto Rico, as well as the U.S. Virgin Islands have some form of the Crown Act. And then if you're in the District of Columbia, just know that there was some anti-hair discrimination laws going back to the 70s. So this is good for employees to know where you have Crown Act rights. And as Kathiana stated, for employees, even if your state doesn't cover the Crown Act, for example, I did a CLE for the Cleveland Bar Association. The state of Ohio has attempted to pass the Crown Act several times. It didn't pass yet, but the state didn't pass it, but several cities in Ohio did, Philadelphia as well. So just be very careful to be aware of, even if you don't have state protection in terms of natural hairstyles, then perhaps you could look to local, or even, as I mentioned, some type of disability statute if applicable. And of course, what
Sorry,
was that?
Tracy, I was just going to say, and I think we didn't mention this, at least not several times, but there have been attempts to pass a federal Crown Act statute, right? It's just not been able to get all the way through to the finish line. But there have been multiple attempts in the past to sort of fill in the gaps on a federal level for different protections where Title VII might fall short given current case law and interpretations of, again, how race is defined or how certain anti-discrimination statutes are interpreted for the scope of their protections. But we will see. I think there is a current one that's moving around in Congress somewhere. I doubt that that's going to see the light of day in the next few years, but it is something that has been that several attempts have been made, and we'll see. It might just be for the next few years that more states or localities pass more state specific or city specific statutes.
And we're saying that in an apolitical way. Yes, it is pending. I think it was reintroduced maybe February of 2025. If you want us to follow up with another CLE, we'd be happy to dive in and review the legislation. I'll let you know why quickly. Based on the way I've seen it, it's a great attempt, but I think it's going to have to take a different path to pass in the current US Congress. But that would be a whole nother CLE. But as Kathiana mentioned, it is a great attempt, and we're very pleased that it has been passed, because truly that's the only way to not have hodgepodge legislation. One state has it, one doesn't. The solution, as Kathiana mentioned, is to have federal legislation, and that would be short of defining Title VII, which I think would take a lot of momentum. But for now, the Crown Act, we're happy that we have a filler for those who are pro Crown Act, and for those who don't want another regulation, you have counsel to help you sort through regulations. But as we mentioned, for employees, know your rights. So part of knowing your rights is knowing which state has enacted the Crown Act, and to be aware of pending federal legislation. And if you are in fact in support of it, reach out to your local congressman or woman. Examples of other forms of protection might be found in Title VII. We went over the difference between employment law and labor law, so you might look to the NLRA, as well as California Crown Act. Review employee handbook and make sure that employers, please don't take down any workplace employment posters. I know that we are in an era of uncertainty in terms of EOs, meaning executive orders, that might conflict with employee rights, but it is against the federal law to take down those posters. So for employers, don't take them down. For employees, continue to read them, because even though executive orders are coming down the pipeline that may seem to negate employee rights, there is an order of authority. So generally in our system of federalism, you're always going to look to case law, statutes, and executive orders. With that being said, I am definitely in favor of following all three. So you want to be aware of EOs, you want to be aware of statutes, and you want to be aware of case law. But we want to try to work with all three sets of law in tandem, keeping in mind the hierarchy of law. And then be aware of internal HR policies and use the complaint channel effectively. So for example, I've seen this over and over again, where employees complain and they believe they have a strong claim, but they forgot one important point. You have to let your employer know, even if there's a concern about retaliation, be aware of potential whistleblower acts or some type of workplace protection, but you have to let your employer know that you feel you've been discriminated against, even if it's something for a lot of people that might be as menial as hair. But for those who dealt with it, not discrimination, but feeling uncomfortable, hair can be a big deal, because it's our appearance and people do judge us based on how we look. We would want that to be more performance, but it matters. And then also be aware of where to file a claim. So the California Civil Rights Department CRD was formerly a different agency, the California Department of Fair Housing and Employment, but now it's changed to the California Civil Rights Department. So just be aware of the name change, but you still have protection. And then employees participate in HR trainings. It's not about Black, it's not about white, it's not about Hispanic or Asian or multiracial. Trainings can be effective, even if it's not titled DEI or affinity groups. There's still an opportunity to participate and provide feedback. And with that, I will turn it over to our moderator and ask if we
I
have
think
any questions.
just before we
Oh.
turn over to questions, I think this is, and again, from the management side here, but some of the pushback against creating a new statute, either, you don't want more regulation, or you feel like, well, Title VII, there is, protections for afros, but as far as other hairstyles, feeling like, well, it's a neutral policy, which again, some of the Crown Act statutes do sort of address in their own way. But there are also protections where, like in your case, Tracy, you mentioned it was tied to a health condition. So maybe then there's an ADA consideration where it might be tied to a religious belief. So we're back in Title VII, but we're talking about religious protections in that instance, and not necessarily race, right? So I think it's important that we sort of go through the exercise of going through the different ways hair might be implicated, even if it's not necessarily tied to a specific hairstyle and race, but maybe it's because there has to be an accommodation for a medical condition or an accommodation for a religious practice.
Absolutely. So for example, we had a slide showing the locks. And if I ask you, Kathiana, when we think of locks, what religion comes to mind? Think about Rasta. Yeah. Exactly. So you want to be very careful. And then in some of the EEOC versus UPS, UPS has been sued a lot. So if anyone here is representing UPS, you definitely want to watch this one again. There was a whole line of cases about hair, and believe it or not, it wasn't women. So we want to be careful also to be sex neutral, because it was primarily men with long beards, and they were Christian, they were a Christian sect, or people wearing hijabs or burqas, right? So it's not always just hair, it could be head coverings, or if someone's Jewish and they're wearing a yarmulke. So there are a lot of different intersectionalities in terms of protected categories. As Kathiana mentioned, it could be race, it could be religion. And now with the current administration and this definition of men and women as two sexes, we also want to be careful about transitioners and any type of gender distinctions that might come into play with hair. Maybe there's a rule that men can wear long hair or short hair and women can't. So also check for hair length. And as we wrap up, hair length was a big issue, because there was recently a case with a student in Texas who actually filed a Crown Act complaint, and the Crown Act did not meet jurisdictional muster. The court threw it out because it said that particular statute didn't mention hair length. And it was a male student who was excluded from school for long, I believe he had dreads, and perhaps there was a grooming code saying girls should have a certain length, boys should have a certain length, or no mention of length at all. So there are a lot of different nuances, and it just means if you're pro Crown Act, very broad to capture, and if you're anti more regulations, then you're going to fight for any way you can to have it dismissed. And with that, I'll actually ask for Kathiana to provide some feedback. Do you think we're leading down the road of being overly regulatory, especially with companies leaving California for that very reason? There's a lot of pushback about that.
I'll reserve any thoughts on that. Let's then just take it to questions.
Yeah, well, I am brave here. As an entrepreneur, I have a little more freedom. I'd say there has to be some type of a medium, right? Because we do want to protect employees, but I do understand the concern about being overly burdensome to employers. So I think as we learn in law school, it depends, but there's definitely room for improvement in terms of how current legislation is being presented. There are a lot of different issues that are not covered.
So we do have 2 more slides left for federal
Mhm.
context and risk mitigation, and then key legal takeaways.
So I'll turn that over to Kathiana for the federal risk, because I think it's closely related to your clients and concerned about compliance.
Yeah, I think, and we touched on this earlier, it's the focus on risk prevention, and making sure that you're compliant with, where applicable, both federal and state rules. And as far as the current climate is concerned, I mean, even with many of the executive orders, a lot of the language also does include the caveat that, you know, you're supposed to follow the law. And if an employee is going to bring a lawsuit, it's not going to be because they necessarily, you know, read the executive order closely and decided something. No, it's going to be under whatever applicable statute applies, whether federal or state. And so you want to be compliant with the law because it's still the law of the land. And so, you know, do your trainings, do review. It's really good to at least do a policy review every year, particularly when it comes to employment policies. But you know, you want a gold star. I think it's every at least twice a year, maybe at the end of Q1. I mean, at the end of, I'm sorry, the first half of the year, so Q2, and then at the end of the year, when a lot of new employment statutes tend to get passed. And really important to have the policies in place for employees where they do feel like they've been harmed, have a means to report the alleged sort of, you know, bad act, right? Whether that's to a supervisor or a sort of third party outside of their reporting channel, where they can reach out and get an investigation going if necessary. And I tend to find, at least with my clients, folks just want to be able to be compliant, and they want guidance on how to do that. They want to be able to treat their employees properly under the law. And sometimes it's not clear, as we went through these different slides. We see, you know, courts sometimes struggle with how to interpret the statutes. These are new statutes, so it's constantly evolving. And so important for employers to frequently review their current handbook and workplace policies, and make sure they have processes in place for employees to address concerns.
What about the slide in terms of identity? How can we still allow employees to possibly associate with affinity groups or have some type of identity in the workplace, but not feel as though they're going to be a target in terms of discrimination?
Yeah, I think that that's more than a hair and hair texture or hairstyle sort of consideration there. Affinity groups are not an illegal, you know, sort of per se prohibited facet of the workplace. Many employers have, given the current climate, taken the approach of maybe removing affinity groups from the workplace. But generally speaking, if you have an affinity group, if it's open to everyone and not restrictive of, okay, well, it's only open to these groups of people, there's not, and you know, something where you're violating the law there. Now, without seeing the policy, without reviewing it, I can't say, you know, for sure. But affinity groups are permissible under even the current executive orders that have been issued. It's just they can't be restrictive to certain classes.
Perfect. I think it's great that we mentioned that, because a lot of employers are now going back, you know, determining what to do based on conflicting EOs from current versus previous administration. So I'll wrap up in 2 minutes with key legal takeaways. The California Crown Act is legally enforceable in the workplace in California. And for those of us who are pro-human rights, I am definitely in favor of it. And if you would like to support the federal legislation, please contact your state and federal representative. Employers must frame workplace policies around neutrality, not preferences, even with affinity groups, as Kathiana just mentioned. Employees have tools to protect their employee rights. They can also complain, right, through a formal channel in the workplace if they feel that they've been discriminated against based on natural hair and protective hairstyles. Employees still have constitutional and civil rights, even with some of the current EOs. Social justice is not dead, it's just being redefined. Aligned with both sides, both state and federal standards for best results, and that's for both employers and employees. And with that, I am very pleased to say we started on time and we're ending on time.
Well, we do want to,
And
I'm not sure if there are any questions, but to the extent we have questions.
there aren't,
We don't,
based
okay.
on what I last saw. So I'm always conscious to get you all back because I know it's probably work hour. But thank you on behalf of the Beverly Hills Bar Association and also the Black Women's Association of Los Angeles made this event possible. They're also a media sponsor. And Kathiana, if you have any closing words.
No, thank you for your time, and Tracy, thank you for sort of spearheading this terrific panel. I appreciate everyone for coming.
Bye, everyone. Thank you. You did great, Kathiana.